chat on point goal.
Yes, Mr. Stewart.
Thank you, Your Honour. So dealing, Mr. Leader, back where we were with the 1962 Father Gulen incident. So the information from the police statement was that Father Gulen had walked in and observed Father Kevin O'Donnell and the complainant in circumstances which, so said the complainant, should have put Father Gulen on notice as to Father Kevin O'Donnell's abuse of him.
Yes, the allegation was that Father Gulen had walked in and seen O'Donnell in bed with a boy.
And Gulen was at that time O'Donnell's assistant parish priest.
In 1962, I think so, yes.
And he was subsequently O'Donnell's executor.
Yes, I understand he was.
Which would suggest that they were close.
Yes, that was certainly what I was wondering about myself at that time.
And depending on just what Father Gulen had said, at least had seen, that could be very significant, because if Gulen had raised the alarm at that time in relation to Kevin O'Donnell, it might have saved many, many victims thereafter.
I absolutely agree.
Including Emma and Katie Foster.
That's so, yes.
In your file note, you record denied, and you said that Father Gulen had denied it. At that time, in other words, of your telephone call on the 30th of November, was that he had denied it to you, or that he had denied it to Mr. O'Callaghan, who had reported that to you?
I don't know. I know that he had denied it to me back in 1988, but I don't know whether he had also denied it to Mr. O'Callaghan.
And then dealing with the 1958 complaint, that's then dealt with in a letter which you attached to your facts. So that's at tab 190, the third page. And this is a letter on 31 October 1994 to Monsignor Cudmore, and it's from Father Gulen.
That's right, and I believe that this letter helps me clarify the confusion I had earlier as to whether Archbishop Little's knowledge was in 1992 or 1994, and this helps me recall that it was 1994. It helps me with the chronology.
And that's because your understanding is that what's recorded in this letter, in other words, Father Gulen's visit to someone, was part of investigating the allegations which arose in 1994.
Yes.
And so if we just have a look at the letter, what Father Gulen's saying is to the Monsignor, the Vicar General, at your request I hereby submit the details of a visit and an interview I had on Friday, 13 September 1994 with, and because there are a few people mentioned here, I'm going to call that Mr. A. So Mr. A is the person being visited at his home. I went to his home at approximately 5:45 p.m. I knew Mr. A from our last stay, 1958 to 1965 in Dandenong, when he was involved with the Scout movement. He was home by himself. He received me well. I had not seen him in our church since my return in 1986, but he claims he attends St. John Vianney's in North Springvale. I brought up the subject of Father O'Donnell, and he expressed great sympathy with this whole affair. Are we to understand from that
by then
public?
There must have been publicity, yes.
As far as he recalls, a young fellow, so we'll refer to him as B, approached him in 1958, he thinks that's the year, regarding interfering by Kevin O'Donnell with this boy. A agreed with B to approach the authorities at the cathedral. He and a Mr. C went to see Monsignor Lawrence Moran, the administrator of the cathedral. He received them well, was kind, and listened to their story, complaint. Monsignor asked them to leave it with him, and he would follow it up. From that day onwards, he was out of the case. So in other words, that's Mr. A was out of it. Is that right? He had only heard from B that someone from the cathedral had come to see Kevin O'Donnell and also had talked to B, and that everything was squared up since that time. At the beginning of this year, possibly March, April, he received a phone call from B with the request that he would testify or make it known what happened in 1958, and that the cathedral was involved and knew all about Kevin O'Donnell and let him carry on. Mr. A refused emphatically to get involved in any way. He told B that he could not understand him. He said he could not believe that these so-called traumas could come up after 35 or more years. He saw it more as a sort of revenge. And B should never forget how good O'Donnell had been to him over many years. Mr. A said that was the end of their conversation, and B had not tried to get in contact since, and Mr. A was still of the same attitude in the matter. So, in brief, B had complained to A in what he thinks was 1958 that O'Donnell had interfered with him, and together they had reported it to Monsignor Moran, is that right? And he had been the administrator of the cathedral, and it had been left with him for follow-up.
Yes.
And of course, once again, if what Mr. A said was true, it's very significant. For more years, in other words, going back from 1962, of abuse by O'Donnell might have been avoided, depending on what had been done by Moran.
I agree.
So your position then was that there was evidence that a senior figure in the Archdiocese had information in 1958 that, properly handled, might have led to O'Donnell being found out then and subsequent abuse then being avoided.
Yes.
Now, you will be aware that there's reference in these documents to there being an agreement between the Archdiocese and Catholic Church insurances that for O'Donnell claims of abuse after 1958, the CCI would not fully indemnify, they would pay only half.
Yes.
What do you know about that agreement?
I understand that that is the agreement, and I understand that it reflects a difference of opinion between CCI and the Archdiocese as to the Archdiocese's entitlement to indemnity in relation to O'Donnell cases.
Can I bring this back to terms that everyone might understand? Is it the position that you established that the Church had knowledge which may indicate that it should have acted and done something about O'Donnell from 1958?
Yes, that's what this indicates.
The consequence of that is that in law, it could be said there was a breach of duty by the Church, and I appreciate the problems defining the Church, but by the Church to those who were subsequently abused by O'Donnell.
Yes, Your Honour. Yes.
So if there had been a vehicle that could have been sued in the relevant sense at the time, then it's very likely that common law claims would have succeeded.
I think that is so.
And as a consequence, it's for that reason that CCI says, well, in circumstances where you had knowledge and did not act, we're not prepared to stand 100% behind the claim.
That was one of the grounds on which CCI relied, yes.
So in lay terms, so that everyone understands, what this means is that the church, you're satisfied the church had knowledge, which if there had been a suitable vehicle to sue, rather than the legal structure which the church actually had, then a common law claim would have succeeded.
I'm satisfied that Monsignor Moran knew. There is clearly a question as to the distinction between Monsignor Moran's knowledge and the church's knowledge. But with that clarification, I agree absolutely.
He's a member of the church and had responsibilities, no doubt, within the church.
Well, I think, Your Honour, that's where there's room for legal debate. Your Honour's seeking to put propositions to me in plain English, and subject to the qualification I've made, I agree with what Your Honour has said.
Well, just so people understand what the qualification might be, the knowledge is knowledge held by a senior member of the church.
Yes.
And does nothing.
Well, I'm not sure that he did nothing. I think what is absolutely clear is whatever he did failed to prevent future abuse.
Yes.
Clearly. And it's terrible.
And the real impediment in terms of recovery, which stood, of course, in everyone's way, was the legal structure of the church.
Yes.
He was the administrator of the cathedral, Moran.
I'm aware that administrator has a particular meaning, and I see that he is described as administrator there. I'm not entirely sure what that means. And I say administrator has a particular meaning within church structure, and I'm not sure what exactly his position was in 1958, but he plainly was a person within the hierarchy. At a point in time, and I don't know whether it was 1958 or later, but at a point in time he was Vicar General, and I believe he became a bishop as well.
Somewhere else in the documents, he's been given another title. I'm just trying to find it quickly. Chief Administrator for the Diocese of Melbourne. So that's in the allegation in the statement of claim. You don't know whether that was an accurate description?
I suspect that the term Chief Administrator is not an accurate description, but as a technical matter, but as I say, he was certainly a person within the hierarchy who, if not a bishop then, became a bishop.
Now, you then, Mr. Leader, had cause to telephone Father Gulen to get his account of these events at 196, tab 196, I think is your file note. Perhaps we can go to the typed version, which is on the 8th page, I think.
I think this is a file note of a face-to-face meeting, not a telephone call.
I stand corrected. So you visited Father Gulen, did you? Or did he come and see you?
I think he came to see me.
And I understand him to have said that in 1958 to 1965, he and Kevin O'Donnell, I take it, lived together in Dandenong.
Yes, I think that I'd be confident that's what the diary notes recording.
And
yes.
he said that he was the assistant.
Yes.
And then he refers to some others.
Yes.
And then he said that O'Donnell left in 1969, presumably went to Hastings, would that be right?
Yes.
And that Gulen and O'Donnell hadn't lived together since then. They were good friends.
Yes.
Am I understanding it correctly?
Yes.
And then in relation to the 1958 allegation, there's some matters that are recorded there, but in substance he denied having seen anything, is that right?
That's right.
Yes. And of course, in relation to what had happened in 1990, at least 1962, which is when the Mr. B had said that he had been walked in on with O'Donnell.
Yes.
You had no reason to prefer Mr. Gulen's account to that of the person who had signed the police statement.
Well, I accepted what Father Gulen told me. I believed him.
Yes, I understand that may be so. And having two contrary accounts of what had occurred, you weren't in a position to prefer Father Gulen's account.
I agree. There was a police statement and there was Father Gulen's account. I suppose whenever one is faced with two conflicting accounts, one sometimes will be unable to decide which version is correct. In other circumstances, one does accept one version over another. I wouldn't want to be in any way understood as suggesting that the victim was not telling the truth or anything like that, but Father Gulen I met with him face to face and I believed what he told me. I believed that he said yes, he had walked, he remembered the incident when O'Donnell had been, excuse me, when O'Donnell had been sick in bed and he'd walked in, but he told me that he did not see anyone in there. That's what he told me, and I believed him.
Well, he also said the room was dark, implying he may not have been able to see if there had been someone in there.
Yeah, yes.
And then he said, I do remember someone coming out of the room later,
Yes.
which would, as it's written there, in any event, suggest that there was someone who'd been in the room, or that someone whom he saw coming out of the room later had been in there earlier.
I'm sure that I was concentrating very closely on what he told me and that I wrote down what he said, and it seemed to me that faced with this very serious allegation that he had seen O'Donnell in bed with a child and done nothing about it, his admission that, and I don't claim in any way to be the best judge of who's telling the truth and who's not, but it did seem to me that he was being frank and honest with me in saying, yes, I remember the incident and I remember walking in. I didn't see anybody in there. Someone came out afterwards. That's what he told me, and I believe that.
Did you ask him who the someone was? Adult, child, someone he knew, someone he didn't know?
I think because I have recorded someone and not the name that he didn't know. It's possible I didn't ask him, but I would expect that I would have, because I agree with you, it's an obvious question to ask.
Okay, 198, there's a file note in relation to your investigation of the Father Silvano allegations in the statements of claim.
Yes.
And I take it what's written here in the first person we to understand is Father Silvano talking to you.
This is the wrong document.
If we look at the typed version, at 198.
No, this is
That's not 198, I don't think. There you go.
Thank you. Yes, I was O'Donnell's assistant. Is clearly me recording Father Salvano telling me that he was O'Donnell's assistant, as in assistant priest.
And the allegation, the relevant allegation in the statement of claim was essentially that Father John Silvano had failed to act upon allegations made to him in, as it was put, early 1992. Is that right?
I think the allegation was rather that Father Salvano had made complaints to Bishop Deacon about O'Donnell.
That had not, and
That had not been acted on, yes.
Yes. And O'Donnell retired in August 1992. You're aware of that?
Yes,
And he was not charged until March 1994.
I think that's right, yes.
Yes. Perhaps we can look at the defences, and since we looked at the Emma statement of claim, we'll look at the Emma defence, but just to look at the statement of claim first, at 182, page 15, paragraph 11. Now, you'll be familiar with this paragraph and the particulars because this deals with the abuse,
Yes.
as it was alleged in the statement of claim. In the period, the plaintiff was subjected to physical and or sexual and or psychological abuse, defined as the abuse whilst an infant student at the school by the deceased, whilst the deceased was carrying out or purportedly carrying out his priestly duties and functions at the school and in the premises, whilst a servant and or agent and or otherwise under the control of the first named to fifth named defendants and or each or other of them as described in paragraph 1. And then the particulars of the abuse are the abuse occurred during class time at school and after Mass on Sundays. It occurred at various sites at the school and or on the premises. The deceased would request that the plaintiff be removed from her class whilst at school or after Mass, would otherwise be required to accompany the deceased in order that she would be involved with him in the discharge of his responsibilities referred to in paragraph 1. On occasions, the deceased would provide the plaintiff with a tainted soft drink which would make her feel, quote, weird. The nature of the abuse included genital contact. Now, I've gone through that, obviously, to then look at what was pleaded in the defence in response to that. And that's at tab 184, page 3, paragraph 11. And it says, as to paragraph 11, that you accept the reference back to the paragraph I've just read.
I do.
1, they, being the defendants, do not admit that the plaintiff was subjected to physical and or sexual and or psychological abuse while an infant by Kevin O'Donnell. And 2, they otherwise deny each and every allegation contained in paragraph 11. So let's deal with the paragraph 1. By then, of course, in other words, by the time the defence was prepared, Mr. O'Callaghan had long since found that Emma had been abused by O'Donnell, is that
Yes,
right?
that's right.
And you had his report and the various annexes to his report.
Yes.
Why did you not admit the abuse, or at least some of it, that which you were able to admit given what you knew from the reports?
I've dealt with this issue in some detail in my statement, and with respect both to the Fosters and to the pleader of the statement of claim. The statement of claim was pleaded in what I would describe as a generic form, in the sense that I had seen the precise formulation of physical and or sexual and or emotional abuse in other cases, the particulars, by which I mean the details to support that allegation, were so vague that in a legal sense, in the context of a pleading and with the precision required of a pleading, it was and is my view that it was not possible to make that admission.
Could you not have pleaded, save to admit that the plaintiff was sexually abused by Kevin O'Donnell? The defendants do not admit the relevant allegations.
I don't think at the end of... I've given this a lot of thought, obviously, in the lead up to the hearing today. I don't think that would have been an appropriate way for defendants to proceed. And because we're dealing with particulars, dealing with pleadings, these are technical matters that, if anyone understands them, lawyers do, but probably not all lawyers even do. But to have adopted the formulation that you're suggesting would have then, in my view, led to the probability that the defendants were asked to particularise what they admitted and what they did not, and the defendants would not have been able to do that.
Would they not have legitimately been able to answer such a request for particularity by saying that they don't know, they don't have knowledge?
I don't believe that would be a permissible, and it certainly would not be a conventional way to plead in Victoria or to particularise matters in Victoria at that time.
Mr. Leader, again, we're in the territory of lawyers, but
yes,
it'll sound to lay people to understand like technical games. Do you understand that?
I do understand that, sir. Yes.
And why wouldn't it, even if Mr. Stewart's suggestion wasn't appropriate, why wouldn't a phone call to the lawyers on the other side have been appropriate to say, look, we know she was abused, but we can't plead to this until we have more particulars. Can you provide them?
Yes, Your Honour, as my statement indicates, there were various other issues with the statement of claim that were the subject of quite significant informal discussions between the lawyers, and the opportunity was offered and accepted by the plaintiffs to replead, I think, on 2 occasions. The point was, I think, this, that at some point between the issue of the proceeding and the trial, if there had been a trial, some more details would have been needed. But consistent with my discussion with the Archbishop about seeking medical examination early, my view, and as I recall the Archbishop's view, and Mr. Exel, who was also instructing me, was that a requirement to provide further details was something that would understandably be difficult for Emma to do, and that it would need to occur at some stage during the proceeding if the proceeding had gone all the way to trial, but that the thing to do first was to clarify some of the other legal issues around the duties that were alleged and so on, and that was what we focused on first. I might say, and I have said in my statement, that I'm obviously aware that I became aware some years later that Mr. and Mrs. Foster were upset by understandably upset by the perception that they had that the Independent Commissioner, having found one thing, the defence then did another. And what I wish to say in response to that is 2 things. First of all, that distress was not conveyed to us at any time during the running of the proceeding, and if it had been, we would certainly have sought to explain that we were in the arena of lawyers dealing with the technical legal pleadings, but that I cannot conceive for 1 minute that had these claims gone to trial, they would have gone to trial with a dispute as to what had actually happened. I'm confident that at some point the plaintiffs would have provided such details as they were able to, and the defendants would have responded.
Did you not see at the time that whatever might be the technicalities about the legal structure of the church and the breach of duty of care, the one thing that would hurt most would be for the church to deny there'd been abuse?
We didn't deny that there was abuse, sir.
Well, didn't admit the abuse.
That's right. And in pleading terms...
Did you not realise that would hurt terribly?
In pleading terms, sir, there is a significant admission, and in particular, I would expect that lawyers reading paragraph 11, 1 and 2 would see the distinction between the do not admit and the deny, and I would expect that lawyers would explain that to their clients if asked. So had the Fosters raised that matter with their own lawyers at the time, I would be confident that an explanation would have been given along the lines that I am suggesting, or had it not, I would have expected that the lawyers for the plaintiff, with whom I believe I had a courteous and constructive professional relationship and continue to have, would have raised the issue with me. Had I been given any inkling at the time that the Fosters had been distressed by this pleading, I would have acted to explain that as best as I could.
Was there a discussion between you and the plaintiff's lawyers about the issue and how the concern was that you wanted more particulars before you pleaded?
No, there wasn't, sir. The discussion, as I say, began and continued with other issues that we had with the pleading, and I'd have to say that given that the pleading was amended several times, and given that there were many discussions between me and Mr. Jurgensen, between me and counsel, and between my counsel and the plaintiff's counsel, and given that we met several times, I would have expected that if that had been an issue, then it would have been raised, so it could have been clarified. I'm sorry that that didn't occur, but all I can say is that it didn't occur, and my view was at the time, and is, that this is an entirely conventional way to plead to that sort of allegation.
Well, can I then just seek to put it into context? You knew from Mr. O'Callaghan that he accepted that she'd been abused.
Yes.
And the issue, leaving aside the issues of suing the church and duty of care and so on, the issue then in terms of the abuse, its relevance in the dispute was as to whether or not it had occasioned the damage, wasn't it?
And the extent of the damage, yes.
Yeah.
Yes.
So that the only relevance of further detail was what?
Well, it's what we just agreed, Your Honour, that what happened is the foundation of the plaintiff's case. Putting to one side the questions of who's liable, there's then the questions that would then have to be determined by the court had the matter gone to trial, would be all the questions of causation and remoteness that Your Honour would, of course, be well familiar with.
That depended on the doctor's opinion, didn't it?
Yes.
So the doctors, your doctors, in discussion with Emma, as they would have done, would have reached a conclusion.
Yes,
they could express.
Yes, and I would have expected, again, had the case not settled, I would have expected that these issues would have been clarified either by an amended pleading or by particulars in the entirely conventional way that these matters are clarified as a proceeding.
Well, that wouldn't have been necessary either, would it? Because the doctor would have consulted with Emma and listened to Emma's account and then formed an opinion. It was only if that opinion took issue with the relationship between the abuse and the medical consequences that there would have been an issue.
With respect, sir, I don't agree with that. One would also have to consider the correlation and the consistency between the pleading in paragraph 11 and what Emma would have told her doctors.
Why would that be necessary?
Well, in my view, sir, the foundation of the case is the allegation of abuse, the foundation of the case is the allegation of abuse, which needs to be described in pleadings or particulars. That's
if there's to be an issue at the trial about whether there was abuse.
And it may be, sir, that there wouldn't have been an issue, and it may well be that once details had been provided, the defence could have been amended to admit, or it could have been dealt with by agreement or whatever. Where we were here was 30 days after the statement of claim is served, we need to file a defence based on what we know, and it was and is my view that the professional obligations on those advising the defendants was to not admit things that were not within their knowledge.
You contemplated that there would be an early medical examination.
Yes.
And that examination would have given you an opinion as to whether or not all of the damage that was apparent was the consequence of abuse, wouldn't it?
I would have contemplated also that the medical opinion would provide further details of what the abuse was.
Well, it might have, but if your doctor's opinion was all of the medical consequences that she's suffering from are occasioned by the abuse, in my professional opinion, would there have been a need to go any further?
There may not have been, no. But at the point at which this document is being pleaded, we did not have that information.
Mr. Leader, on another occasion, you'll recall, and it's the email we looked at earlier from you to Jennifer Cook some time later, you gave a different explanation as to why the abuse had not been admitted. And the explanation you gave on that occasion was that it had been alleged that Emma had been raped, and that hadn't been established, and that's why it hadn't been admitted. Did you recall that explanation?
I recall that explanation. That explanation was incorrect. I had confused in my mind the details as pleaded in the statement of claim and the details as provided at the mediation. Yes. And I might say, sir, that had the case not settled at mediation, then with the benefit of details that had been provided at the mediation, and assuming that they were then provided on an open basis, there clearly would have been amendments to the defence to reflect that. Indeed, I would have expected there probably would have been either an amendment to the statement of claim or some particulars provided. But in one way or another, I am confident that the parties would have worked cooperatively to take that issue out of the dispute.
Yes, if the professional advice had been that your doctors were satisfied that the medical condition was a consequence of the abuse, that would have been the end of that issue altogether.
Yes, yes. But we weren't in that position at the time of pleading to the statement of claim.
I want to move on and address the question of settlement. Generally, in this case, in the Foster's case, what were your instructions with regard to settlement of these claims?
My instructions were to settle them.
Mr. Excel's statement, if I recall it correctly, says that he had instructions from the Archbishop early on to settle them if at all possible, and I take it those then became your instructions.
Yes.
Were you given instructions as to the amount that you might settle for?
No.
How did you yourself identify what was the appropriate amount?
It was a result of the negotiations at the mediation.
Well, I understand that.
Yes.
How did you identify that it's appropriate on behalf of your client for you to say yes?
Your Honour, there are certainly mediations that I attend with instructions in other matters and in commercial matters and so on, with a view as to where a settlement might occur, and then, as Your Honour would understand, sometimes the negotiations proceed in a way that you settle within that range, sometimes you don't settle, sometimes you make a decision to settle outside that range. My memory of, if you like, the writing instructions that I had when I went to the mediation with Mr Exel was that we were to do our best to settle the case if possible.
How did you arrive at the view that you're doing your best?
Well, I think we got to the point where there had been some negotiations backwards and forwards, which are detailed in Mrs Foster's statement, and with which my diary notes confirm agreement. And we got to a point that the total amount of $750,000 was a point from which the Fosters were not prepared to move, and it was a point that was an amount to which the church agreed.
Tell me, did your advice to the church as to what may have been an appropriate sum to agree to, was it influenced by the difficulties the Fosters faced in suing the church? I globalise that. Did that influence?
Yes, it did.
It follows from what you said as to your instructions that it was not your instructions to fight this case to judgment to establish a precedent for the church.
That's correct.
And those instructions that you had in this case with regard to settle if possible, were those the same in other cases you were handling during the time of Archbishop Hart?
There weren't any other cases by that time. So what had happened by that time was that the proceedings that were on foot in 1996 when the Melbourne response,
that's the 30 or so that
30 or so, had all been resolved one way or another, either through, largely through the Melbourne response, or else through, I think a couple had perhaps been resolved through negotiations, but they had all been resolved, I think, I'd say some years before the period that we're now in.
Well, during the time of Archbishop Pell or Archbishop Hart, or both?
Certainly some were resolved during the time of Archbishop Pell, of course. Whether they were all resolved before Archbishop Pell moved to Sydney and Archbishop Hart became Archbishop, I can't quite recall.
Was there to you a discernible difference in approach with regard to fighting or settling litigation between Archbishop Pell and Archbishop Hart?
No.
Now, there was a settlement conference on 24 June 2005. That, as I understand from your statement, just involved the lawyers, is that right?
Yes, that's right.
And nothing was resolved then?
No.
But I suppose that was at least a useful start in the discussions, was it?
Yes.
And then there was a mediation on the 7th of November 2005 in which all the actions were settled, is that right?
That's right.
And we can have a look at your statement, paragraph 160. Where you say the Archbishop and Mr. Excel expressed the strongly held views that every effort should be made to settle the litigation. What did you understand motivated that view? What was in it for the church to settle the litigation?
What was in it for the church was to provide the Foster family with a meaningful remedy for what had happened to them. And what was in it for the church was also that a settlement rather than litigation involves the saving of legal costs on both sides. I think what was in it for the church was the recognition that if the case had gone to trial and the church had won, that would nevertheless, while that would be a legal victory, that would not be a victory that the Archbishop would have enjoyed.
Now that, you'd appreciate that stands in contrast to the approach taken by the Archbishop in Sydney in relation to the Ellis litigation, where one might say that the Archdiocese did enjoy the victory as a precedent.
Yes, I see that distinction.
Now the cases were settled, as we've heard, at $750,000 plus solicitor client costs and no continuing support through CareLink.
Yes.
That's the sum of it, isn't it? At tab 208, well, sorry, before we go there, stay where we are on the screen. At 161, you'll see that it's said there by you, in relation to the legal costs, significant legal costs, which you referred to earlier in your oral evidence, and it said it seemed unlikely that the Archdiocese would ever seek to recover its costs from the Fosters if and when they lost. Why did that seem to you at that time to be unlikely?
Because it's my view that Archbishop Hart and Mr. Exel and I would all have taken the view that, having regard to what O'Donnell had done to those girls, that would have been a completely inappropriate thing to do.
And you're aware, once again, that that stands somewhat in contrast to the approach taken in Sydney in the Ellis case with regard to recovery of costs?
For a period of time, yes, and I believe that ultimately the Sydney Archdiocese came to the same view in relation to Mr. Ellis. That's
yes,
my understanding.
Ultimately,
yes.
At tab 208 is Mr. Collins's advice on the settlement. Now, just to understand, this arose because, as I understand it, you offered to the insurers an advice as to why the matter had been settled at that level, and they took up that offer. Is that right?
Yes, the settlement had been reached without any involvement of the insurers and without any participation of the insurers at mediation. And when, as I understand it, the Archdiocese then went to CCI to say, well, we've settled this case for this amount of money and we seek indemnity, the insurer sought some, as you say, the insurer accepted the offer that I made to seek a written memorandum from Mr. Collins.
And I take it that you agreed and accepted the reasons given by Mr. Collins as recorded in his memorandum?
Yes.
Now, dealing then with the insurance, if we can go to tab 212. So, firstly, as I understand it, as recorded in this letter from Catholic Church Insurances to Mr. Ted Exel, the business manager, in December 2006, the principal sum was settled by paying half in accordance with the agreement you referred to. Is that right?
Yes.
And then if we look at 217, this then deals with the legal costs that is the Archdiocese's own legal costs being for the most part, I suppose, causes invoices to the Archdiocese for defending and settling the claims. Would that be right?
I recollect that the total cause costs were about $35,000, and I think the difference between the $35,000 and that $65,000 comprised council's fees, our share of the cost of the mediation, the costs of the cost consultant who had assisted in resolving the claim by Williams Winter on behalf of the Fosters for their legal costs and so on.
In relation to the cost consultant, I may be wrong, but I think that came later. But in any event, it's not a significant amount. But the legal costs were $65,000 approximately, of which the insurers paid half.
I can't. The insurers paid half. The $65,000 amount doesn't actually ring true to me, but it may be. I know that our costs were around about $35,000, and that that was obviously significantly less than the Foster's costs.
You'll see that that says I've attached a spreadsheet outlining the payments. And then if we look at the next page, the tax invoice numbers that are given in the left-hand column, do you recognise those as being cause invoice numbers?
It's possible. It's possible. The amounts seem to be amounts for both cause fees and disbursements, but I can't, looking at that, really shed any more light on what those numbers mean. But if the position is that ultimately the total costs in disbursements were $65,000, then that's what they were. As I say, my recollection is that they were a bit lower than that.
Yes. Well, the schedule seems to indicate they were, including of GST, 65,085. But in any event, that once again stands in stark contrast to the costs in excess of 10 times that in the Ellis litigation. I don't know if you're aware of that.
I'm not.
And then at 218, the matter of the Foster's legal costs are dealt with. So, in other words, the agreement had been that the church, speaking loosely, would pay those costs on a solicitor and client basis.
Yes.
A cost consultant was employed to scrutinise those, and they were settled as to an amount that would be paid.
He provided her opinion that once the costing process had been gone through, the Foster's legal costs would tax out at between $113,000 and $123,000, and the settlement was agreed at $122,000.
Yes. And then at 220, tab 220, CCI paid half of those as well.
Yes, I don't have personal knowledge of these matters, but that seems to be what the letter says.
And then at 221, we have the question of CareLink expenses.
Yes.
And it's a bit hard to follow this email, but this is Joseph Bucci, case manager, special issues at CCI, to one of his colleagues, Marita Wright. And he sets out the costs that were accepted. And as I understand it, what was accepted is the total of $81,324, including educational costs of $27,000, of which CCI then paid half.
I don't see the figure that you just mentioned, but
all right,
I mean, this is an internal.
All right, let's scroll down a little bit.
An internal CCI email that I've not
yes, I
seen,
appreciate
I don't
that.
think.
Do you not have any personal knowledge as to what settlement was paid by CCI in relation to CareLink and related costs?
Look, I don't think so. No, I don't have any recollection of it.
in any event, you'll see there's a series of sums that add up, series of amounts that add up to 54,000, then there's an additional 27, a total of 81, and then there's a discrepancy that's calculated of 11,926, and as I read the email, on the basis that there would be no more after that, CCI paid half of the 81,000 figure, but we can leave that to another time to try and understand the email. Now, in Mr. Hurstbush's case, I understand you had very little involvement.
Yes, that's right. I think in terms of the progress of Mr. Hirschbach's case through the Melbourne response, I'd describe my involvement in that as being typical of the level of involvement that I have in most cases, which is none at all prior to the claim going to the compensation panel, and then I do have a role in, which we've seen in part in relation to Emma Foster's claim as well. I have a role in making of the offer, but I made the offer to Mr. Hirschbach on behalf of the Archbishop based on the compensation panel's recommendation, and when he accepted the offer, I facilitated the payment and so on.
Yes. Well, perhaps it's worth looking at the offer at 251. And that's your offer to Mr. Hirschbach on behalf of your client, is that right?
Yes.
And that's in the amended terms post your discussion with Susan Crennan.
I think so, yes. If
We
could just
scroll
keep
down,
scrolling.
you'll see that. At the foot of the page and then
Yes.
over the page.
Yes.
Yes. Yeah, there you go.
Yes.
And so the consequence of that, as I understand it, is that it only sought without prejudice confidentiality and no reference to defending any legal action that might be taken.
That's right.
Yes. And that offer was accepted. And then at 255, that was then submitted by the Archdiocese to CCI. And to your knowledge, that was then accepted and paid.
I don't have any knowledge of this, I'm sorry.
That's at 258. Okay, and then in the case of AFA, in that case, of course, the independent commissioner upheld the complaint, and AFA applied to the compensation panel.
Yes.
Is that right?
That's right.
And at what stage did you become aware of that complaint?
As with Mr. Hirschbach, at the time that the compensation panel was getting ready to meet with him.
And
I can't say that I'm not sure in the case of Mr. AFA that I actually did become aware at that time. Those documents passed through Coors' office, but I don't have any memory of that actually happening, but clearly I've signed some correspondence.
someone in your office may have handled it?
Yes. Yeah.
Because there wasn't anything particularly striking or difficult about the manner in which you had to deal with that, was there?
In the sense of the procedural aspect going through the Melbourne response, no,
Yes.
obviously for him there was.
Of
Yes,
course,
Of
yes.
course.
And at 285 is your offer of compensation, and that was not accepted initially, as I understand it. Is that right?
Yes, that's right.
And you deal with that at 286. Perhaps we can look at the second page of 286 first. So that's an email from AFA to you on the 28th of June 2011.
Yes, it is.
And he says, starting at the end of the first line, I regret that I have to reject the offer of compensation as inadequate given the impact that sexual abuse by Catholic clergy has had on my life. In summary, the impacts are ongoing physical, emotional and mental suffering that I have endured since the offences occurred, as well as the financial loss of approximately $250,000 in lost wages due to major depressive disorder, precluding me from undertaking employment. And then on the previous page is you forwarding that to Francis Moore. What was his position in the Archdiocese?
By then he had replaced Mr. Exel and became the business manager, subsequently the Executive Director Administration of the Archdiocese.
Yes. And you made then a recommendation to the Vicar General, or I beg your pardon, to Mr. Exel, start again, to Mr. Moore, basically to say that Mr. AFA can sue if he wants to, but the offer will remain open for acceptance.
I think what I said was that were his case to succeed, then succeed in a legal sense, then the amounts of money he was talking about, without really knowing anything, having any particular details about his earning capacity or anything, but that the propositions he was putting were eminently reasonable as a probable outcome of litigation if it was won, but that based on the timing, in particular, based on the fact that he had been abused by Glennon at a time prior to any complaints about Glennon coming forward, then based on the law as it then was, his claim would not succeed.
And at 293 is CCI's claim summary in relation to this claim. You've seen this document before, I take it?
I don't think that I have.
In any event, on page 3, you'll see that there's a schedule of figures. You can have a look at that, where LMR, I take it as lorry rolls. Do you know that?
I don't know.
And the various items are set out as to what the claim was by the church to CCI, and including one of Coors fees for $9,300. You look surprised, Mr. Leader.
I find that inexplicable. That can't be right.
Well, I was going to ask you about that, but perhaps that's the answer.
It's not a document I've seen before, but that I can't explain that.
What this document does raise is one question, which is how the ongoing care or support through CareLink, which could take years into the future, would be dealt with at the level of insurance. Was that something that was raised and resolved in the Melbourne response?
I don't know the answer to your question. I know that there were discussions. I know I was involved in some discussions with Mr. Exel and CCI many years ago, probably within the first few years of the Melbourne response, about the issue of recovering compensation payments if indemnity was granted, and recovering a contribution to the costs of running the Melbourne response if indemnity was granted. And my best memory is that the question of the ongoing future costs that were paid through CareLink was one that the insurer found itself unable to contemplate in insurance terms, and that it was left unresolved. That's my best memory, and that perhaps there is a process of the Archdiocese going back to CCI later, but I really just can't remember.
Oh, very well. If you don't know, you don't know.
I don't know.
And Mr. Leader, just to advise you that in relation to the two transcripts, our intention is to, once we've got them appropriately redacted and so on, is to, that's of the interview between Professor Ball and the Fosters, to tender those, which will deal with that issue that you raised earlier. Those are my questions, Your Honour.
Yes. Does anyone else have any questions? No,
Yes, I do, Your Honour.
yes.
Seckle is my name, Mr Leader, up here on behalf of the Fosters. Mr Leader, could you just set out to the Commission your qualifications, please?
I have an economics degree and a law degree from Monash University and a diploma in media law, a postgraduate diploma in media law from Melbourne University.
And are they or is that the extent of your qualification?
Yes.
Yes. You don't have any qualifications in respect of matters of psychology?
No, I don't.
Nor do you have any qualifications in respect of matters psychiatric?
I don't.
Yes. You're aware when you gave your evidence to the Commission this morning that Ms Sue Sharkey had prepared a report, and in fact that report had been provided to Mr O'Callaghan, and Mr O'Callaghan subsequently used that as consideration for his ultimate finding that went to the compensation panel. Do you recall that?
I don't, no.
Okay, I'll read it to you. Your Honour, if I could go to Mr O'Callaghan's statement, please, page 32, paragraph 7. And perhaps before I do that, if I could take the Commission to page 22 of Mr O'Callaghan's statement. And you'll see at page 22, if we can just scroll down somewhat, please. We'll stop there. You'll see that private and confidential report to compensation panel re Emma Foster. Now, Mr Leader, that that is the commencement of extracts that are then taken from that report and culminate at page 32 of that statement, and in particular paragraph 7, and you'll see there, Mr Leader, paragraph 7, extract from report of Sue Sharkey of CareLink.
Yes.
And I'll read it to you. It would appear that Emma's claims to having been abused by Kevin O'Donnell are true. Emma's presenting psychological and psychiatric behaviours are consistent with serious abuse. Because of Emma's age, it may be many years before the real story is known. Now, at the time of giving your evidence this morning, you were aware of that, weren't you? That opinion?
I certainly would have seen it.
Yes.
Before, you asked me before about it, and I said a moment ago, and I said I didn't remember it.
But it's clear that
but clearly I did know. I'm not saying that I hadn't seen it before.
Yeah,
Clearly I
so
had.
it's just so we're clear about it. Prior to you giving your evidence to this Commission this morning, you were aware of that sentiment, that opinion,
yes,
and that descriptor as to the severity of abuse.
yes,
We also know, and if I can take, well, I don't need to take you to it, it's been put to you by counsel assisting the report from Nikki Maheris, the family therapist, and we know, and I can't recall, I beg your pardon, Your Honour, it's Exhibit 16.8. Perhaps if that could be brought up on the screen. And we know, Mr Leader, do we not, that this was a report that was provided to you for the purpose of your comment upon it by Vicar General Prowse. That was in about April of 2003.
yes.
And likewise, it follows that prior to you giving your evidence to the Commission this morning, you were aware of the contents of this report.
Yes,
Yes.
I certainly don't. When I looked at it this morning, I didn't have an independent recollection of having seen it before, but clearly I did.
Yes,
I had seen it, there's no doubt.
Yeah.
Because
you're asked to
advised
comment upon it.
Yes, and I did comment on it.
Yes.
Whenever it was, 10,
So there's no
15 years
doubt
ago.
that you'd seen it. No doubt that you'd seen it prior to you giving your evidence to the Commission this morning.
Yes, at about the time it's dated, yes.
I'll read it to you. Nikki Maheris, and just in terms of her qualifications, Mr Leader, I have over 17 years' experience working in the health and welfare field, and within this time have provided counselling services to many families where trauma, violence and sexual abuse has occurred. I've been providing counselling services to the foster family for over 2 years. These sessions have included contact with Emma Foster. A summary of her current status is provided below. Emma has experienced sexual abuse perpetrated by a Catholic Church priest. The abuse occurred over a prolonged period commencing as early as age 6. Disclosure about the abuse did not occur until after Emma as a teenager became a patient of a mental health service showing symptoms of anorexia, substance abuse, self-harming and suicidality. These symptoms are present in nearly all cases of survivors of prolonged sexual abuse. Treatment of such symptoms is made more difficult if patients are not stabilised in secure and supportive accommodation. The abuse creates a lack of safety, and lack of safety in other situations exacerbates the symptoms. Emma has not been able to maintain her accommodation within the family home because of these symptoms and their impact on family relationships. To preserve these family relationships and to ensure that Emma does not become cut off and socially isolated from vital support networks, it has been necessary for her to leave home. Her parents continue to provide emotional and practical support in a way that can be more useful to Emma from the position of living away. If I can then take you to the second last paragraph of that report. The complex symptoms that Emma presents with are a direct result of the violent abuse she was subjected to as a child. Now, that was a report that you were aware of, and sentiments as to diagnosis and severity and nature of abuse prior to your evidence to this Commission this morning.
Yes.
Mr Leader, if I can take you please to document and tab 138, Your Honour. Mr Leader, you'll recognise this as your letter to the Foster family, which was one of 3 letters, including a letter from then Archbishop Pell and the findings of the compensation panel.
Yes.
If I can take you, and firstly, I'm very conscious of your evidence to the Commission yesterday, Mr Leader, where you averted to the perceived difficulties that you were having with a particular solicitor, and therefore the need to include the word strenuously defended in letters that went out to people. Firstly, if I can take you to the top of this letter, this is obviously, a letter that, this was obviously not a letter to any solicitor, was it?
No, it wasn't.
And indeed, the solicitor to which you referred yesterday was not the solicitor who ultimately acted for the Fosters.
That's correct.
If I can take you then to paragraph 3, and in particular the phrase that's used and has been repeated before this Commission on many occasions, and I'll read it. The compensation offer, together with the services that remain available through CareLink, are offered to Emma by the Archbishop in the hope that they will assist her recovery and provide a realistic alternative to litigation that will otherwise be strenuously defended. What was your justification for including those words, strenuously defended, to the Fosters?
As I sought to explain yesterday, those words were words that were introduced in 1996 for the reasons that I explained. They were used in every letter of offer that was made up until this time, and as I said yesterday and as I said in my statement, they were inappropriate. And I think I apologised yesterday, and I certainly apologise now.
Thank you, Mr. Slater.
Does anyone else have any questions?
No, I do, sir. Just a few matters. Mr. Leader,
You identify yourself for those watching.
My name's Jeremy Ruskin, and with Mr. Hoyne, Your Honour, I appear for Mr. Leader, and you know that, Mr. Leader. Mr. Leader, you gave some evidence about Professor Ball, and you gave evidence about the fact that he had experience with respect to paedophile priests, but on the other hand, he was a very experienced and, as you saw it, appropriate person to assist in this exercise that you were undertaking. Is that correct?
That's correct.
Just putting aside his CV and his experience, which we will see in his statement, did you have personal dialogue with him to make your own assessment of him as a person and as to whether he would be objective?
I did. I should say that we've spent quite a deal of time talking about my role in relation to the establishment of the Melbourne response. The decisions such as who would be appointed were certainly not mine, but yes, I did over the years, I think both before he was appointed and after I had contact with him.
And what was your evaluation of him, face to face as it were?
I found him to be a very sympathetic man who I found easy to talk to. I found that he was able to explain issues in a plain English, well, I'm struggling to explain it, but I found that he was able to express himself well and to explain issues to me in a way that I found easy to understand.
And his expertise?
He clearly, as far as I could see, had significant expertise.
You also told us that you had other psychiatrists available to cope with the very problem that faced with the Fosters. Where did these other psychiatrists come from? In the area of sexual abuse or where?
Well, in the case of the Fosters, they had an existing relationship with, they were already being seen by a psychiatrist who was someone who, as I recall, Professor Ball knew and thought highly of and thought was appropriately experienced.
Thank you. I'm jumping to another topic. You were asked some questions by counsel assisting about the police statement with respect to the other case, which you called ID, and the affidavit and the statement that was annexed to it. Is that correct? Your Honour, I want to show the witness this. I see as I look at it that with respect to the police statement, there's a name which will need to be redacted. So to do it properly, could I first just show it to, counsel has it and we've got copies. Can I show it to the witness but make sure when it is tendered, which I seek to do, that there's a redaction of the name? Thank you.
Yes.
Would you, if we got just a spare copy, please. Thank you. If that could be just shown to Mr. Leader to identify. Oh, thank you. Now, what we're able to see here, conforming to your evidence that this is a case involving somebody called ID, there's an affidavit from a solicitor which says, I want to amend the statement of claim, and it's with respect to the matters involving the evidence of Father Dwellan. Is that correct?
That's correct.
And then annexed as Exhibit RM2 is the police statement concerning the complainant in that case. Is that correct?
Yes, that's right.
Yes. And that's the document that you're referring to, which was the product of discussion with Mr O'Callaghan?
That's the document that I was clearly referring to in the facts that I sent to Mr Lyons after I'd spoken with Mr O'Callaghan. Yes.
Good. Your Honour, I tender that with the condition that the name be excised.
Yes, Your Honour, we've prepared a redacted one in any event. I intended tendering it, so
With that could have a number.
Do we tender it now?
Tender it now, although we'd like the opportunity to check the redactions before it's published, but
We'll wait till you've checked it and then we'll take it in.
Thank you. That's perfectly satisfactory. The point of this, in the way you gave your evidence, so we can clarify it, is you spoke of Mr O'Callaghan having not just complainant files, but he had unconfidential files, if you like, of a police kind involving various priests, including O'Donnell. Is that right?
I believe so. That's what he's told me, yes.
Yes. And so, in respect of the information concerning this police statement, in terms of where its provenance was, what do you say as to its provenance?
Well, I say that the copy that I had, and that is the subject of this exhibit, I had received in the ID proceeding, and I had it.
Yes.
I think from looking at the diary notes and my and the facts and so on, that it seems probable that Mr O'Callaghan must have had it as well.
From the police files?
Yes.
And if that's the case, is it within the is it within propriety that he gives you something from the police file as distinct from the confidential files?
Well, yeah, that would seem to me to be so, yes.
Now, this is a different topic. You were asked some questions about the pleading, the non-admission, and you've given a lot of evidence about that. And in your statement, you talk about the fact that it was a compound pleading, if I can do that, and you've explained that. In your whole dealing with the Foster case, including the mediation, and your discussions with the solicitor, was the topic of possible distress from that raised with you?
No.
But looking now at what might happen in the future, which is what we're interested in, what do you say about any value in, if this was repeated in some, His Honour raised the question of a phone call, in respect of a letter that might ameliorate or solve the misunderstanding that what comes from the pleading isn't intended to cause distress? How do you see that playing a part?
I think that is precisely what I would do, and that one way or another I'd seek to have discussions with the plaintiff's solicitors, both as to the issue of what ultimately is contested and what is not contested in the litigation, but also, I suppose, make it clear that I'd really be guided by the plaintiff's solicitors as to the appropriate, the most appropriate way of obtaining whatever information needs to be obtained. I'd really seek to, I would like to think that I understand the difficulties and the sensitivities of this, and that I'd act appropriately.
Thank you.
You appreciate, of course, that what happened in the light of a letter that says we're going to strenuously defend immediately raises concerns, doesn't it?
Yes,
whether expressed or not.
I do. I would say, sir, that the way in which the litigation was ultimately run was not that it was strenuously defended at all. It was defended for a period of time and settled, I think, some 18 months after first being issued.
You gave some evidence, I think, on that topic of strenuous defend, and that after the complaint you had discussions with Susan Crennan QC, as she then was, immediately having been alerted to the very problem we've talked about today, and that was dealt with quickly?
Yes, and I would have, I'm sure, had discussions with the Archdiocese as well.
Of course, of course. I'll go back in less than a minute to a topic. You were asked some questions about your interview with Father Gwellan and that you believed him. Just apart from what he said, how did he say it? What was his manner, demeanour, and how old was he, by the way, when you had this?
I believe that he's well into his 80s now, so I suppose then he would have been in his 70s, I think.
And in terms of how he impressed you as a witness of truth and reliability, what do you say?
He did impress me as a witness of truth, and I think there was a sense in talking to him that he absolutely understood the seriousness of what was being put against him, and all I can say is that he impressed me as being genuine, and I suppose somewhat affronted that it would be said of him that he had seen this and done nothing.
Putting the question negatively, have you been in situations where you might interview a witness but find conversely that he might be evasive or unreliable, in your own opinion?
Yes.
All right. Now, the final question is this. We've heard about the mediation, and there are notes of the mediation in our book. Am I right in saying this? You were represented by very experienced senior counsel and junior counsel, that is your side of the case?
Yes.
The plaintiff was represented by very experienced senior counsel and junior counsel.
Yes.
You had an experienced mediator.
Yes, we did.
Who was a barrister, very experienced in this particular area.
Yes,
is that correct? Who played a role in the whole process.
He did, yes.
And in relation to the negotiations, we can read it for ourselves, but back and forth there were submissions, if I can put it that way, that there were real liability issues, some concessions by the other side, and in the normal way that mediations work, eventually a figure that both sides found accommodating was arrived at.
That's right, yes.
Your Honour, Your Honour, I have no further re-examination.
Thank you. There's just one question I should have asked you earlier. I asked you about discussions you had with church people when you first became involved in these issues. We've heard on other occasions that there was a view in the church that may have influenced the conduct that we've seen, that this was a moral failure rather than a criminal issue. Was that ever discussed with you?
I think only in the context of it being disagreed with. Certainly I know from my discussions with Cardinal Pell and with Archbishop Hart and with the various vicars general that I've dealt with over the years, that view that sex abuse is only a moral issue is one that they find quite repugnant, quite wrong.
What about discussions with others in the church?
I don't. I am confident that I have not had that discussion with anyone in the church, because if I had, I would recall it as something that I disagreed with.
Now, I understand when you say they found it a repugnant view, but I assume from what you've said that they acknowledged to you that there had been that view in the church.
Yes.
Yeah. Yes. Mr. Ruskin, you've got nothing on that, I assume?
No, I have no more questions. Thank you.
Mr. Stewart?
No, nothing further, Your Honour.
Thank you, Mr. Leader. Thank you for
Your Honour.
Giving us your evidence, and you're now formally excused.
Thank you.
I think we should adjourn and resume again at 4 o'clock.